Hello, and welcome to Topic 5. We'll be focusing on civil rights this week, and this is the first lecture that takes a look at civil rights, equality, and the United States Constitution. Okay, so what are we going to be looking at in this lecture? Well, the first thing we're going to do is we're just going to quickly talk about the role that equality plays in American political culture. That's a concept that we talked about earlier in the semester, and I just wanted to kind of bring it back to that topic. We're going to take a look at the 14th Amendment and, in particular, the Equal Protection Clause, because the Equal Protection Clause is enormously important for civil rights. Then we're going to be taking a look at the difference between justified and unjustified unequal treatment. And then we'll finish out the lecture by taking a look at the different standards or levels of scrutiny that the Supreme Court uses when looking at the 14th Amendment's Equal Protection Clause. Equality, as we know, is a key value of the American political culture. Earlier this semester, we talked about how democracy, equality, and liberty are really those beliefs that underpin the American creed. And as we know, these are embedded in key American documents. Up at the top, we have the famous quote from the Declaration of Independence that we hold these truths to be self-evident, that all men are created equal. But we also know that we haven't lived up to this ideal, that it is in our founding documents and you can't take those away, but that as a nation, we've worked long and hard to basically make good on those promises that are outlined in our founding documents. Martin Luther King Jr., at his famous March on Washington, he gave the speech, "I Have a Dream," and in it, he talks about this thing called the promissory note. And just to capture or to quote from the speech, he basically says that, in a sense, we've come to our nation's capital to cash a check. When the architects of our republic wrote the magnificent words of the Constitution and the Declaration of Independence, they were signing a promissory note to which every American was to fall heir. This note was a promise that all men, yes, black men and white men, black women and white women, would be guaranteed the unalienable rights of life, liberty, and the pursuit of happiness. It's obvious today that America has defaulted on this promissory note, insofar as her citizens of color are concerned. Instead of honoring this sacred obligation, America has given the Negro people a bad check, a check which has come back marked insufficient funds. I bring that quote up because I think it's a good way of thinking about these founding values, such as equality, that we've made a promise to our people, but it's up to the people to hold their government accountable and to fight for equal treatment and to basically change that promissory note from being insufficient funds to being fully sufficient funds. And that's what the United States Civil Rights Movement is about. It's an ongoing battle for equal treatment in the eyes of the law. And it's gone on for a long time, and it will continue to go on as long as we exist as a country. Okay, so where do we find equality in the Constitution? Well, following the Civil War, 3 amendments were added to the United States Constitution. The 13th Amendment was added in 1865, and it abolishes slavery. The 15th Amendment was added in 1870, and it forbids denying the right to vote based on race. The 14th Amendment was added to the Constitution in 1868. And the main goal of the 14th Amendment, it did several things, but one of the main goals of the 14th Amendment was to tell states that they could not do certain things. Remember back to our previous lecture on civil liberties, and remember we talked about how the Bill of Rights did not apply until the passage of the 14th Amendment. The Bill of Rights was not seen as applying to the actions of the state governments, only to the actions of the federal government. That changes with the addition of the 14th Amendment because the 14th Amendment is designed to tell states that they can't do things. Coming out of the Civil War, there was a lot of concern that states, in particular Confederate states that came back to join the Union, that they would try to take away the rights of people who are now free but were former slaves. And so there are three clauses that are in the 14th Amendment that we're going to take a look at. One of the clauses is most important for our discussions today on civil rights. The first clause is called the Privileges and Immunities Clause, and it says that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Early on, after the passage of the 14th Amendment, that was seen as treating former slaves equally in terms of not taking away certain privileges from them. But it's the very last clause, the Equal Protection Clause, that goes a lot further. It says that no state shall deny any person within its jurisdiction the equal protection of the law. In other words, that in the eyes of the law, people must be treated the same. The middle clause, the Due Process Clause, we talked about that in our civil liberties section. And that says that no state shall deprive any person of liberty, life, liberty, or property without the due process of law. And remember that that was the clause that was used to incorporate the Bill of Rights to the states. So what is the equal protection of law? Equal protection of the law is telling the government that they must treat an individual in the same manner as other individuals that are in similar conditions or circumstances. So in other words, the equal protection forces a state to govern impartially, to not draw distinctions between individuals solely on differences that are irrelevant to a legitimate government objective. And that's why the Equal Protection Clause is so crucial for the protection of civil rights. And so, to put that more simply, equal protection of law is treating an individual in the same manners as others when it comes to law. And that, discrimination is this different treatment. Now, what we're going to talk about now is that there's some times when we treat people differently, that's allowed under the law. It's permissible, and therefore constitutional. There are other times when we treat people differently in law that is seen as impermissible or unconstitutional. The question is how do we determine what kind of different treatment is allowable and what kind of different treatment is not allowable and unconstitutional? So impermissible discrimination, that is unjustified, treating people differently for no reason, no justification. So impermissible discrimination is making distinctions between individuals that are irrelevant and that there's no basis in reason. And so maybe a good extreme example of that would be treating people with blue eyes and brown eyes differently, okay? The color of your eyes have absolutely nothing to do with your intelligence, your ability, any other sort of individual traits or characteristics. It's just the color of your eyes, that's all. And so treating people with blue eyes and brown eyes differently would be impermissible discrimination. Some types of discrimination, though, can be permissible if there's a legitimate reason for that difference. And so, for example, we treat people who are citizens and non-citizens differently, particularly when it comes to voting. If you want to vote in national elections, you have to be basically a naturalized citizen, and that it's reasonable to not let non-citizens participate in who's going to vote to determine who our president will be or members of Congress. And so, there's a legitimate reason for treating citizens and non-citizens differently when it comes to national voting. The question is how do we determine what is permissible and what is not? And this next slide will help us with that. So before we take a look at the way the courts answer the question about what is permissible and impermissible discrimination, let's take a look at these different groups and just sort of ask yourselves, do you think it's reasonable to treat these groups of people differently? So, what about adults and minors? We have a lot of laws on the books that treat adults and minors differently. That minors can't drive cars, at least those under the age of 16. We don't let minors purchase alcohol or tobacco. We treat adults and minors differently when it comes to the criminal justice system. Well, you must get the idea that that's permissible to treat those different categories differently because they are allowable in law. But ask yourself, why is it permissible? What are the major differences between adults and minors? Um, I mean, we think about sort of cognitive differences, impulse control differences, etc. What about people who hold a license and don't hold a license? And so we know that it's permissible to treat people with licenses and not licenses differently. So you have to have a license to practice medicine, to practice dentistry, to become a hair cutter, a beautician. But why is it? Why do we treat those groups differently? And I think it's easy to see why those are different and reasonable differences, because there are clearly differences between those who have a license to practice medicine and those who do not. These are a little bit more difficult, though, these categories. Men and women, black folks and white folks, LGBTQ folks, that would be lesbian, gay, bisexual, trans, or queer folks, and straight folks. And I'll put the last one up there, poor and non-poor folks. And so, when we think about the difference between adults and minors, there's clear differences in terms of their cognitive ability. Very young children don't understand the difference between right and wrong. Most adults do. When it comes to decision making and impulse control, most adults are able to compile their, look at the, a cost benefit analysis and, make less impulsive decisions. Children have a more difficult time to do that. So we can see the different treatment there. But is it justified to treat men and women differently? Are there real differences between men and women? Well, of course there are. There are biological differences. Women can get pregnant, men cannot get pregnant. But to what degree do those differences matter in terms of treatment in the eyes of the law? Black and white folks, are there differences? Well, race is an immutable characteristic. You don't choose the color of your skin, but much like eye color, the color of your skin doesn't have anything to do with the other individual traits such as intelligence, hard work, etc. Right? However, both with men and women and blacks and whites, you could say that there are differences in terms of their lived experiences. Most African Americans came to the United States not by free will, but because they were brought here as a part of the slave trade, starting in the early part of the 17th century. And their experience from that point forward has been an experience of legalized discrimination. So maybe there is some justification for treating those two groups differently. Same with men and women and LGBTQ folks and straight folks. The lived experiences of women and men are quite different, as the lived experiences of queer folks and straight folks. Okay. But what differences are there important differences between those groups? We can see that there's biological differences between men and women. How important are those? Are there biological differences between lesbian, gay folks and straight folks? And if there are differences, are there of those differences of any import? And then looking at poor and non-poor and how poor people might be treated differently in the eyes of the law in terms of tax credits or being able to get food stamps and those sorts of things. Are those different treatment permissible? Well, we may all have an opinion about what constitutes permissible and impermissible discrimination, but our opinions really don't matter unless we are sitting on the Supreme Court. I'm not saying that our opinions don't matter, because how the country feels about what is permissible or justified discrimination is not oftentimes drives who sits on the Supreme Court, since we elect presidents who then put people on the Supreme Court that are in theory supposed to reflect the will of the people. And not only that, and maybe more importantly, that who we elect to Congress reflects our understanding of what is permissible and impermissible discrimination, and that plays itself out in civil rights laws. But at the end of the day, it is the Supreme Court who is asked the question, is this different treatment constitutional? And they answer that question. So they have a big role, they play a big role in terms of our understanding of equal treatment or equal protection of the law. And let's take a look at the different standards that the Supreme Court uses to figure out whether or not different treatment is in fact constitutional. Okay, so your textbook talks about how the court uses 3 different levels or 3 different standards to evaluate whether or not the Equal Protection Clause has been violated. There's the first, second, and third level. And the lower the level, the more likely it is that different treatment is going to be considered permissible or constitutional. The higher the level, the more difficult it is for the state to justify different treatment. So let's take a look at those different levels. The first level is called the rational basis test, okay? And that the rational basis test is the lowest level of scrutiny that is applied by the courts, and therefore it makes it easier for the state to treat people differently. The rational basis test says that the only time different treatment is unconstitutional is if there's absolutely no rational basis for the different treatment. So if there's no rational basis for the law to treat people differently, then that's the only time that law is deemed unconstitutional. But if the state can come up with a rational reason for the different treatment, then they will say that the different treatment is allowable. We're going to go with the eye color example again as impermissible. There is no rational reason to treat people with different eye color differently. And so if you were to pass a law saying that only people with brown eyes can vote, it'd be like, hell no, that's clearly there's no rational reason for that difference. Permissible, though, is adults and minors. Permissible is the poor and the not poor. Permissible is people who have license and don't have license. Why? Because there's a rational reason for adults and minors to be treated differently. Now, that doesn't mean that a minor, a younger person, couldn't challenge a law that treats a minor differently than an adult, saying that it violates the Equal Protection Clause. They could very well do that. The difference is that it is the person challenging the law that has to prove that there's absolutely no reason for that law that treats people differently to be on the books. So the burden of proof is placed upon the person that is experiencing that discrimination, and they have to make an argument to the court to say that the law is in fact irrational. Makes it pretty difficult to do, and not that it's impossible, but it's very difficult to do. And so it makes it a lot easier to justify different treatment within the law. The second level, or the second standard that is used by the Supreme Court, is what is known as the intermediate scrutiny test. This is a stronger test than the rational basis test that we just talked about. It's stronger because the state must show that the law is reasonable, that there's some rationality for why we have this law. But they also have to take the second step, and that they have to say that not only is this law reasonable, but that this law is related to a really important interest of the state, okay? So being reasonable in and of itself is not enough. You have to say, we have to have this law because it serves a really important function that the state must satisfy. This is the standard that's used for gender and sexual orientation. So in a second, age gets a lower scrutiny by the court. As we're going to see in a moment, race gets the highest level of scrutiny from the court. But the court uses a lower level to when people are treated differently in the law based on their sex or their sexual orientation. Now, here's an example of a rational law, but a law that is not related to an important interest. And I teach a class on sex, power, and public policy, and we just looked at a bunch of Supreme Court cases that deal with laws that treat men and women differently. And this example of administrative convenience is a good example. Why? Well, when it came to treating men and women differently, the court used to use the lower level, the rational basis test. But over the years, they've used a more strict test, the intermediate scrutiny test. And in one case we read about, this was a case where the state of Utah had rules regarding administering an adult child's estate. And so if you had an adult child who was not married and they had an estate, money, savings, those kinds of things, and they died and they didn't have a will, and the mom and the dad were still alive, the state of Utah said that the man would be the one who would be the administrator of the child's estate. Well, a woman who had a much closer relationship with her adult child than the father did. The father left early on in the marriage, even though the father was still the biological father. The woman, she said, no, wait a second, that's not fair. There's really no reason to treat men and women differently when it comes to who should administer the state. Well, the state came back and they said, no, this is rational. They said it was rational because it's administratively convenient, that we don't want husbands and wives arguing in the courts to argue over who's going to be the administrator of their child's estate. We're going to cut through the red tape. We don't want the administrative hassle, so we're just going to default to men. And anyways, men are better with money than women. Well, under the rational basis test, that might have likely survived. But when you look at administrative convenience, you could say that's really not, there might be a rational reason for that, like reducing, caseloads in the courts, but that's not related to an important interest of the state. And so under the immediate scrutiny test, that kind of law would be deemed unconstitutional. It makes it more difficult to discriminate between people, but it's still possible. And here's an example where we see that possibility when it comes to pregnancy leave. Okay, so if your company offers pregnancy leave and you're a man and you're not pregnant because you can't get pregnant, it's justified that the pregnant person gets the leave when the unpregnant person does not get the leave. For one, you're in different categories, and also making sure that a worker is able to recover from having a child, that's an important interest of the state. However, if your job allows you to have parental leave, that is after the pregnancy and after your recovery, you just want to spend time with your kid bonding, not just, but you want to bond with your kid. Well, if you offer that to women, you've got to offer that to men as well, because treating men and women differently when it comes to parental leave is not really rational, right? Because both men and women can bond with their children. The third test the third level that the court uses when it comes to equal protection of the law is what's known as the strict scrutiny test. And some say that the strict scrutiny test is strict in law, but fatal in fact. In other words, it's really difficult for the state to justify unequal treatment when the court uses the strict scrutiny test, although it's not completely impossible. Unlike the second level test, that the state has to show, obviously, that the law is rational. But they have to say that the reason that they're treating people differently isn't because of an important interest, but of a compelling interest. That the function that the state is trying to achieve is of paramount importance, like national security or something like that. Furthermore, they need to achieve this goal in a way that is the least restrictive way of doing it. Okay, if there's another way to achieve that goal that doesn't include treating people differently, you got to take that route. Okay, this is the test that is used for what's called suspect categories. And so race, ethnicity, religion, national origin, those are seen as suspect categories. So whenever there's a law that treats black and white people differently, or Latinos and non-Latinos differently, it's a red flag to the court. And the court's like, man, we've got to give this law a really, really, really strict looking at. It also protects essential rights, such as your right to speak and the freedom of the press. Under this test, it's very, very difficult for different treatment to be considered constitutional. But it's not impossible. Here's two examples that your textbook talks about when it comes to different treatment and race. Now, we did actually talk about how there might be some reasons for why you might want to treat Black and white people differently. And one of those reasons is the different experiences and the historic levels of discrimination that African Americans have experienced in the United States that white Americans have not. And so, as we know, that we have, your textbook talks about this thing called affirmative action. That is where you have laws in place or policies in place that tries to affirmatively or positively address the harms that have come from discrimination. And you know that you've applied to a state school, and when you apply to a state school, that race is taken into consideration on your application. They ask you what your race is, they ask you what your gender is, and that is something that can be used to admit you among many features or categories that you have into college. Well, as you know, that the question has come to the court. In other words, is treating white applicants and Black applicants, is that a violation of the Equal Protection Clause or is it not? And so that you'll be learning in this chapter that if schools use racial quotas, that is that we have 100 seats for the incoming class, 80 are going to go to whites and 20 are going to go to Blacks. They say, nope, racial quotas are unconstitutional. Why? Because even though it's important that the incoming class has a diversity of viewpoints, there are other ways that you can achieve that goal without doing set-aside quotas. And that's where Race Plus comes into play. If race is one of many different characteristics and qualities that the admissions board looks at, they say that is justified. It's not just one thing you're looking at, but you're looking at race in relationship to other factors as well. And the Supreme Court has said that viewpoint diversity is a compelling state interest, that it's really important that in the classroom we get a lot of different points of view. And so they've allowed that different treatment, or at least taking race into consideration when it comes to applications. They've allowed that because they said that it's the least restrictive way to do it, and it's in a way that you can achieve a compelling state interest. Okay, so that just gives you some additional information to think about as you're reading about the cases in the text as it relates to civil rights. Keep in mind that when we're fighting for the equality, the answer to the question is different treatment based on race, sex, religion, ability, permissible. It's very important how that question is answered, and we get different answers to those questions over time. The answer to those questions changes over time, and we see that with race. In 1898, when there were different train cars, one for Blacks and one for whites, the court said that different treatment was absolutely constitutional. And then we see less than 60 years later in Brown versus the Board of Education in 1954, the court changes its mind and says that kind of treatment is impermissible. It's unconstitutional. And so the answer to that question is very important because it defines civil rights policy and it defines civil rights law. And as the answers to those questions change, so does policy and law. And a lot of the driver for what changes those answers has to do with the movements, the demands that people make for their government to treat them equally. So in the next set of slides, we're going to take a look at the civil rights movements in the United States, what their goals were and how they've achieved their goals. Okay, thanks a lot for your time.